This is Michael Bryce and Lisa Waller versus Daniel Rapp and Max Hicks. Who do I have on behalf of the plaintiff, Bryce and Waller?
Yes, Your Honor.
Who do I have for Bryce and Waller?
Sorry, that's one person. That's me, Bryce Waller, and my wife, Lisa Waller.
You're here representing yourself. Okay, fantastic. Good afternoon,
Yes.
Mr. Waller. Do I have someone here on behalf of the defendant, Daniel Rapp?
Yes, ma'am. My name is Chris Grandinetti. I am here appearing pro bono as a courtesy to help Mrs. Rapp with this and ongoing litigation that I will explain to the court.
All right. Good afternoon, Mr. Grandinetti. Mr. Waller, why was this eviction filed?
Non-payment of rent.
How much is the monthly rent?
$10,000.
Is this a residence or commercial?
It's a residence.
All right. Is there any subsidy on the rent?
There's not.
What months have been unpaid?
January 2026.
How about February? Was February paid?
The lease actually ended at the end of January, and she's now a holdover tenant. So February has not been paid either. But January was the last one on the lease.
Does your lease speak to what happens if you have a holdover?
It does.
Okay. Are you wanting to seek anything for February rent, or are you just asking about January?
No, I will be eventually seeking damages for February as well, but she's still in the property. Yes, ma'am.
Mr. Waller, today is your day in court. If you win your eviction, I'm going to return possession to you. Do you want an award for unpaid rent through February, or do you want to seek that someplace else?
Yes, I do want an award for unpaid rent through February.
So as part of your hearing today, you want to include the February rent?
Yes.
Okay. January and February. Is this property under the Federal CARES Act?
No.
What day did you provide the notice to vacate?
January 15th, 2026.
All right. How long did you provide the defendant?
1 day.
Was that notice to pay or vacate, or only to vacate?
That was to, give me just a second. Vacate only.
Had the tenant previously been late on the rent?
Yes, Your
Had you
Honor.
given them an opportunity to pay or vacate then?
Yes, I had.
When was that?
That was in December of last year.
Okay. All right, Mr. Grandinetti, good afternoon. Mr. Wallace,
Good afternoon, Your Honor.
About non-payment. So first question, is $10,000 the correct monthly rent?
Yes, ma'am.
All right. Has January been paid?
Not to my knowledge, no.
Has February been paid?
No.
All right. What would be the defense reason, or what information would you share with me now?
Well, Your Honor, it's kind of a convoluted case, but this goes back to an existing litigation that's currently ongoing between our client, Ms. Rapp, and between her husband. The parties initially were engaged in a petition for divorce and a suit affecting the parent-child relationship about a year ago.
Say the parties. Do you mean Ms. Hicks and Mr. Rapp, or do you mean the defendants and the plaintiff?
I mean Miss Rapp and her husband, the tenants.
The tenants are going through a divorce.
That's correct. Okay. And so when this began, about a year ago, the parties had entered into a mediated settlement agreement. Part of that mediated settlement agreement specifically required Mr. Hicks to not only provide child support and other health care for the child, but also pay the rent specific to this property. That continued up until about November, I believe it was.
Okay.
Or even before. So there were severe breaches of that mediated settlement agreement, which, and the biggest problem was that the MSA was never actually turned into a court order. So all we have is a binding MSA contract. Now, the subject of that MSA is subject to litigation, and there is an existing request to strike the MSA, set it aside, along with some issues regarding the marital residence and this particular residence. Now, there was a marital house that was just foreclosed on last week. There was a petition for emergency relief with regard to that property and to this specific property to address some monies owed to Mr. Waller. I certainly understand Mr. Waller's situation, and I believe he actually communicated with the attorney of record in the civil litigation that's ongoing. His name is Mr. Molinar. The parties weren't able to come to an understanding with regard to addressing the immediate issue. So I understand Mr. Waller's position. The problem that we have here is that Ms. Rapp is unable to pay. She has nowhere to go, or she's from Florida. All her family's in Florida. We have another request for temporary restraining order in civil court, and specifically we're asking that the court allow Ms. Rapp to return to Florida so her parents can help her with the living situation. And
All
if
right,
she
Mr.
is,
Grandinetti, with respect, it sounds as though what you're saying is that your client, her soon-to-be ex-husband, didn't pay the rent as required, and as a result, her name's still on the lease, and so they're both going to be evicted today. Cool.
that is correct. And
Plaintiff, I've got 10,000 for January. For February through today of 10 days, it's $357 per day, so I get $35.71. So judgment for the plaintiff, $13,571.
Excuse me, Judge.
Mr. Waller.
I would like to retract the judgment for rent. I would like to pursue that elsewhere, please.
So you just want possession?
I want possession.
Okay, judgment for the plaintiff with possession only plus cost of court. I do need to set an appeal bond. I'll put $10,000. That seems more than reasonable for both parties. Mr. Grandinetti, I understand the situation that you've explained. I'm not going to involve myself in the divorce. Best of luck with that. You have 5 days for your client. Understand the situation. If you appeal or do not, I'll just give you this. If no party takes any action, the plaintiff can receive the writ of possession on day 6. That is the soonest that either client, either Mr. Rapp or Hicks, would be forced to leave the premises, right? If the case is appealed and rent is paid at the $10,000 rate going forward, parties can stay in possession until a new court hears that case. State law just changed, though. That case will be heard by the county court within 21 days. Okay?
And Your Honor, just a quick question.
Absolutely,
Would
sir.
the court consider allowing her to make the eviction date effective at the end of February?
I don't have that option, Mr. Grandinetti. It's effective today unless it's appealed.
Understood. Thank you, Your Honor.
Thank you all very much. All parties are excused.
Thank you.
Thank you. Ms. Clarkos, tell me, why was this eviction filed?
This is failure to pay rent. Rent is $1,006 a month. She owes December through the prorate of February.
1,006?
Yes.
Okay, I thought I heard it wrong. I started to write down 1,600 and had to think again. 1006. Okay, go ahead. I'm sorry.
She owes December through the prorate of February for a total of $2,371.28 and back rent through today. A 30-day notice to vacate or notice to pay was given on December 5th. We're seeking back rent, court costs, and possession, and there's no government subsidy on this.
All right. Good afternoon, Ms. Gooden.
Good afternoon, Judge.
Ms. Clarkos is here. She's representing the landlord, Bell South Parks, whatever the name of your complex is. They've got kind of these run-on names. Anyway, Ms. Clarkos said this case is about a relatively recent situation with finances. Is it correct that the flat rent is $1,006?
Yes, Your Honor.
And then is it correct that December, January, not February, are unpaid?
Yes, Your Honor.
All right. Well, with that information, then Ms. Gooden, the landlord meets their burden for a non-payment matter. But as you've heard me probably tell to everyone here, if there's any questions, this is your chance. I want to give you information and let you kind of know definitively from the court side what the timeline is. Immediately, any questions?
No, I just want to speak on my behalf.
Okay. Well, this is your opportunity.
Yes, Your Honor. So the day that the eviction was filed, they did give me a letter on December 5th. I emailed Ms. Cadlin Tadwell, one of the assistant managers, right before. I happened to email her before she filed on that date, and I was just letting her know that I was going to be paying 1 month's rent and that I was just behind and I just had some check issues. She let me know in email that day, here I have it on my phone, that that she appreciated me reaching out to her for communication, but that the 30-day notice ended on the 4th. And so they were going to be filing me for eviction. But she also let me know that if I was able to bring the account balance paid in full, including all applicable fees prior to the court date that will be set by the Justice of Peace, we'd be able to order a one-time courtesy. And she told me on January 5th that my new balance on my account was $3,083 and 92, or I'm sorry, $3,083.92, including legal fees. That's the past due balance for December, January, and then all my late fees. And this was on January 5th. I don't have access to the renters portal, and I asked her how I would be making the payment. Because I used to use Whips at Walmart. I just like enter my account number and I give them the payment. She told me I wasn't gonna have access to the rentals portal or Whips anymore. And so that's why she had emailed me my updated balance. Yesterday, I went to go give them the money orders, and I have them right here, the 3. It's $3,100, but it's 4 money orders. Okay. And I went to go give them the money orders to pay. And I was informed by one of the, not the manager, but one of the workers that the balance had increased because they charged February's rent. And I didn't know. So I was just confused because I had the email that told me that as long as I paid the $3,083.92, that the eviction would be delayed. And I didn't find out till yesterday that I owe totally. And I have she sent me, because I ended up emailing her because they told me that was the quickest way to get in contact with her. And she emailed me back last night with the ledger or the ledger. And it shows that I now owe $4,300.98. Yeah. But according to her agreement, she told me as long as I paid the $3,083.92 before my court date, which was today, then they would be able to stop the eviction.
All right. Ms. Gooden, I can give you information. All right. Because what you've said to me is not uncommon. I've heard similar stories, and I understand sort of both sides to that. Well, I understand why both sides may be in the situation. It's not uncommon for the landlord to say at a certain point they can't accept either payment or partial payment. But now that we've had the hearing and there's a judgment, right? The amount that I'm awarding today. So here's a couple of things. The number that they've asked today is for December, January, and they want only 10 days of the month of February, right? So the number I'm giving is $2,371. That's all $1,006 for December, all $1,006 for January. And then we took $1,006 divided by 28 days of February and multiplied it by 10. And that's the amount that you're getting for February. Now that's the court's rule. And in court, the goal is that it's only the rent, no late fees, no utilities, no cleaning. And the court tries to step it up, say, okay, if the landlord wants possession back, this is there. Now you have your land, go and relet it. All right. That's why we don't give the whole month. Other courts will give the whole month. I'm pretty strict about it. But under your lease, Ms. Gooden, under the lease, what day is rent due?
On the 1st.
So that's why February is due in full per your lease, but in court, I'm only giving them through 10 days. So the number you're getting from court is going to be smaller, quite likely, than the final move out tally they're going to give you, because that number will include the late fees and utilities, which in an eviction can't be included. They're under the lease, but just not given in court. So I'll tell you this, the judgment I'm giving you is just a number, right? It's not the number the landlord really wanted. The number the landlord wants is probably the one on the portal. In the next 5 days, there's nothing that stops you from contacting Ms. Tidwell or someone else at the landlord. And if you have all the money and they're willing to accept it, the landlord has an option to tell me they don't wish to proceed with an eviction, but they don't have to do that, right, Ms. Gooden? They could say, you're a lovely person, we wish you best, go rent someplace else. We're gonna move along. If you don't do anything, though, the judgment for 2371 becomes final, and that would be something that would be discoverable as a credit history against you, and whether that might have an impact. All right.
Yes, Your Honor.
So you have 5 days to appeal, and in that time, you can talk to your landlord. If you don't do anything, well, even if you do all those things, you might still end up with a judgment, but just some information about what happens. Okay.
Okay.
All right.
So I would just have to talk to my landlord.
There's no harm in asking to talk to the landlord and see if some resolution can be reached in the next 5 days. But if nothing happens or you don't appeal, that judgment is final on day 6. Okay.
Yes, Your Honor. Thank you.
Very best of luck to you, Ms. Gooden. And certainly, if you've got a certain amount of money, contact the landlord. Let's see what they want to do. All right.
Okay. Thank you.
Thank you very much. Ms. Garcos, thank you. Judgment for plaintiff, 2371 plus cost. For appeal, we'll put that also at 1 month of rent. So either party can appeal with $1,006. All right, thank you. All parties are excused. Why was this eviction filed?
Non-payment of rent,
How much is the monthly rent?
$13.45.
Any subsidy?
No,
What months are unpaid?
January and then February.
All right, is this a CARES property?
No,
Had tenant previously been late on the rent?
yes, every month.
All
Not
right.
every month.
Had previously the tenant been given a notice to pay or vacate?
Yes.
When was that?
In August, I believe, is when we had filed last time.
That's not the question, Ms. Bates. Did y'all give
Oh.
her a letter that said either pay or leave?
Oh,
Did she
yes,
get to
yes,
pay?
we did.
Okay.
Yes, it
All right.
was on the 7th of January.
Okay, Ms. Bates, because the law changed January 1st, so this is why we got to ask it a different way now. Because the notice to vacate y'all did last year doesn't count anymore. The law now requires that you have to, as the landlord, not you particularly, but landlords must give the tenant a chance to pay or vacate unless you have previously given them that in the leasing period. So in the leasing period you're currently suing on, had she been given a chance to pay or vacate prior?
Yes,
And it said that, it said pay or vacate, not just
yes,
notice to
yes,
vacate.
the notice, yes.
It said pay or vacate.
It says notice to vacate. I mean, it's the.
That's not the same thing, Ms. Bates, right? It is literally a distinction. Also, what y'all gave is just a notice to vacate, and then you would let him pay. The law now requires that it absolutely say pay or vacate by a date. Did you give her a chance to pay or vacate, or did you just say vacate? And then if she had paid you to let her go, does it say pay or vacate?
I guess not. I'm sorry. I wasn't aware of the.
Yeah, January 1st. This is much harder for the landlord. Despite everything in the courts or all the news telling y'all it got easier, it's actually much harder. Your notice to vacate is required now to either give her a chance to pay, and you have to make sure that the day it ends on isn't a weekend or a holiday, or they get extended.
Okay.
Ms. Bates, do you want to look? So here's the law. This is for your help, for everyone, y'all. The new standard under the property code, January 1st, is that a tenant who is deficient in rent within that rental period must be given a chance to pay or vacate. They get a freebie. Now that might include late fees and all this stuff, but they have to be given an opportunity to pay up before you file the eviction. If you've already given them one chance to pay or vacate and they paid, and now they're late again, now you can give just a standard notice to vacate. So that would be the question, Ms. Bates. If in the time period of the lease you're in, she's been given a chance that says pay or vacate, then a notice to vacate is valid. If that hasn't happened and you just gave her
Okay.
a notice
Yes,
to
I
vacate,
understand.
then you haven't done enough and the case is going to
Right.
be judgment for
Okay. No, I understand. I have not done that. I just sent the notice to vacate. I did not realize I had to send because it used to be the notice of proposed yeah.
Yeah, no, Ms. Bates, you're not alone. We're going to have kind of a little, probably a 45, 60-day period of wait, what? Because it
Yeah.
is very different now.
Yeah.
Ms. Bates, we're still in the midst of your case. So you have two options here, since you're kind of looking through your information. You can non-suit, or I can make judgment for defendant and it can be appealed.
I'm sorry, we can what?
You have two options, Ms. Bates, because you are still technically telling me your case. You have not rested. So you have an option to tell me, Judge, I wish to non-suit your decision, or I can give judgment for the defendant because the wrong kind of notice was given. And that means either one of you can appeal.
Oh, okay. I'm sorry.
You're, Ms. Bates, you're just fine. I can make a decision for you and
Please
find
do.
judgment for the defendant. That way you have the right to appeal. You can
Yes,
start the whole
please.
thing over. You can do as you like. All right.
Yes, please.
I would find lack of proper service. It's really about the notice.
Yeah.
Ms. Witherspoon, you were served. You knew you had the hearing today. It's the type
Yes.
of notice that's different now. So, all right. I would put down that either.
I would like to pay. I would like to pay
You're per the law. You're going to get an opportunity. All right.
okay.
I would put the appeal bond at $250.
Okay.
All right. Ms. Bates, thank you. Ms. Witherspoon,
Thank you.
I know that's a lot of strange information there, but it is a big change, and we're gonna get it all working out here. So thank y'all very much then. All right, all parties are excused. Mr. Diggs, why was this eviction filed?
Non-payment of rent,
How much is the monthly rent?
$1,200.
Any subsidy?
No.
What months are unpaid?
Portion of December, all of January and February.
How much was owed for December still?
$345.
Was a chance to pay or vacate provided?
Your Honor, so a notice to vacate was given to the tenant. However, if I may, I would just kind of want to present my interpretation of the section 24.005 of the property code as it pertains to the notice to pay or vacate.
Did you give a notice to pay or vacate?
We gave just the notice to vacate. However, that was because the tenant was late in the months prior, which the property code stipulates that if the tenant were late in the prior month.
The statute is now this, Mr. Diggs. You've got to give them a chance to pay or vacate. So if they were late last year, in any of those notices, did they pay or vacate?
No, Your Honor.
That's what's required now.
Okay.
If you had filed, if you had filed to evictor in December, the minute she was late, you'd been called. But y'all filed in this year, and now you are stuck with that rule. You've got to give a chance to pay or vacate. There's no waiver of that.
Okay.
It is the trickiest part of the new statute change that I think is going to be happening to landlords. It's in a cycle, right? So that's open to its thing. But if there's never been a chance to pay or vacate.
Yes, Your Honor. May I just read you the sentence that I'm reading from the property code?
Go for
it. To me, it's reading, in a forcible detainer suit against a tenant whose right of possession is terminated based on non-payment of rent and who was late or delinquent in paying rent to the landlord in the month in which the notice was given, written notice under this section may be given in the form of either a notice to pay and vacate or a notice to vacate.
I've only been taught that it has to be a pay or vacate, Mr. Diggs, but you can appeal and see if county court disagrees.
Okay.
All right, judgment for defendant, lack of notice. We'll put the appeal bond at $250.
So, what exactly does that mean? I'm sorry, is it, can I
Ms.
ask questions
Patterson?
now?
No, I give you an
Okay.
answer. Ms. Patterson, without going into whether or not you owe rent, right? Mr. Diggs says you haven't paid rent, and that may be very well true.
Yeah,
Mr. Diggs and his client are getting caught in a very specific change in Texas property code. The
Yeah, I
new
was listening.
says that the tenant is always going to be given a chance to pay or vacate unless you've been given that chance previously in a rental period.
Yes, ma'am. So,
Okay.
so what does that mean now, though? Does that mean that they now can give me this pay or vacate notice and then they start over essentially?
I'm not going to answer that. That sounds like I'd be giving legal advice to Mr. Diggs about how to pursue his case, and I can't do that. I'd say that certainly the landlord can follow the law in any way they want. He can appeal my decision. He can do both. If the situation remains, though, that rent was owed and not been paid, at some point, landlord's probably going to end up successfully.
Yeah.
Okay.
Well, yeah, I agree. It needs to be paid, but what do I do now? What does this mean for me?
Ms. Patterson, you don't have to do anything now. The case has been found in your favor. If Mr. Diggs or the Allred or the landlord files an appeal, you will be given notice of that appeal, and then you got to go to a different court date. You may also receive a new notice to vacate from Mr. Diggs or someone on behalf of the landlord, and then just follow or do as you like with that and contact an attorney. But for hearing today, it's all done.
Okay.
All right. All parties are excused. Thank you very much.
Thank you.
Thank you.
All right. And then we are going on down. That was 26137. Bell Fund 6. This is Bell Fund Parks again versus Anna De Luna and others. For Bell Fund
Nationwide.
Do I have someone here on behalf of Anna De Luna? Anna De Luna?
Yeah, it's Anna. Yes,
Anna, I'm so sorry. Thank you, Ms. De Luna. Good afternoon. Thank you for being here.
No
All right, Ms. Parker.
worries.
Why was this eviction filed?
This is failure to pay rent. Rent is $14.46 a month.
Can you see me? Well, I guess.
Yes, Ms. De Luna, I can see you. Good afternoon. All right, Ms. Sarkos, you said rent was $14.46.
Yes, she owes November through the prorated of February for a total of $4,854.42 in back rent through today. A 30-day notice to vacate was given on December 5th, and it also did include the notice to pay in there as well. We're seeking back rent, court costs, and possession.
All right, any subsidy?
No, Your Honor.
Good afternoon, Ms. De Luna.
Good afternoon,
Ms.
Judge.
Marcos is here representing the landlord. And she says the cases, as I've heard, I think everything I've heard today was about non-payment matters. It is a tough economy out there. Ms. De Luna, my first question is it correct that the flat rent is $1,446?
Yes, Your Honor.
Okay. And then is it correct that November, December, January, and February remain unpaid?
Yes.
All right, well, Ms. De Luna, I appreciate that. The situation is probably very tough right now, but those facts on their own, they do give rise to the eviction for the landlord. This is your opportunity. Can I answer any questions? Do you have information you want to share with the court for any reason?
I just do have a question on my docket. It said that the amount is $4,338, and I believe Nationwide said $4,854.42.
That's probably increased from the time they filed it through the date of the actual hearing.
Oh, got it. Got it.
That's it. All right. That's a good question, Ms. De Luna. That's a great question because, right, sometimes like, why is the number different? Any others?
No, Your Honor. Honestly, Miss Caitlin has been extremely patient and understanding. The irony is that I was unemployed and I started a job that would have been more than enough, but I'm actually having trouble with my new job with accounts payable paying me on time as a contract employee. But
Ms. De Luna.
Yeah, and I'm not going to say which school district. I'm not going to say which school district, but I am having challenges to get paid on time, and it's been one error after another from their part. And Caitlin has been extremely supportive and helpful, and my experience has been truly a blessing. And I was just really hoping to avoid this, but unfortunately, we're here.
Well, Ms. De Luna, thank you, and thank you for working in school. And I'm sorry that you're having the frustrations you can't like. My heart goes out to you. Okay, a lot of empathy. Thank you for coming. Let me give you the final number, and then certainly you've heard what I've said to people. You have at least 5 days to appeal. In that time, it sounds like you've had a good relationship. Thank you for being so polite about Ms. Tidwell and the work. Sometimes everyone wants to have the outcome. Sometimes it just doesn't work out for us. All right, well, today it's going to be a judgment for the plaintiff. I go with the $4,854 number. That's November, January, December, and then 10 days for the month of February. The only extra thing that will be added would be the cost of court. To appeal for either party, I'll put the appeal bond at $28.92. That's twice the rent. Ms. De Luna, though, if you want to appeal, you may very well qualify with an affidavit of inability for that. And then rent is due at $14.46. Okay? All right.
Yes, Your Honor.
Very best of luck to you, ma'am. And that school better pay you.
I'm about to
I don't know. Best of luck with that. All right.
Step maybe next for that. But I'm like, really? Like this is a great job. Appreciate it. You have a great rest of the day.
Best of luck to you, Ms. De Luna. Thank you very much. Ms. Carcos, Ms. Tidwell, all parties to that are excused. Thank you.
Thank you, Your Honor.
2693 Avanath. No, this is also a Canvas versus Victor Ramirez on behalf of Canvas.
Nationwide.
Do I have someone here on behalf of Victor Ramirez? Let's see, Mr. Ramirez, you'll need to unmute, sir. If you can press star.
Okay. All right.
Good afternoon.
Hi, how are you? Good afternoon.
All right. Ms. Carcos, why is this eviction filed?
This is failure to pay rent. Rent is $820 a month. He owes December through the prorate of February for a total of $1,932.85 in back rent through today 30-day notice to vacate was given to him on December 4th. A notice to vacate or notice to pay was given to him on December 4th. There's no government subsidy. We're seeking back rent, court cost, and possession.
All right. Good afternoon, Mr. Ramirez.
Good afternoon, Judge.
Thank you for your patience. I know you've sat through a lot of cases already. Ms. Carcos is here. She says the landlord suit or is seeking an eviction about non-payment matters. So is the flat monthly rent $820?
Yeah, actually, I leave the apartment right now. I don't live more in that apartment. So I don't have more money for pay the rent.
All right. Well, I appreciate that, Mr. Ramirez. Sometimes, what we want to be able to do, we just can't. Mr. Ramirez, is it correct that December, January, and February were not paid?
Yes, Your Honor.
All right. Well, I appreciate that then. With that, it's a judgment for the plaintiff. Mr. Ramirez, I'd like to give parties an opportunity to respond or to give me any information or to ask questions. Do you have any questions for me?
No, actually, no.
All right. So it's a judgment for the plaintiff. I'll find that you owe $1,932 in rent. And Mr. Ramirez, you have 5 days to appeal. I'll set the appeal bond at $820, which is equal to rent. If neither party does anything, Mr. Ramirez, the soonest the landlord can make you move is day 6. Okay?
So I need to pay that money in 5 days? Oh, what do you?
You owe that much money. I find that you owe the landlord $1,932 for December rent, January's rent, and a prorated amount for the month of February. Okay? If you don't move out or appeal and you are still there, the landlord can make you leave beginning on day 6 after today. Okay?
All right.
All right.
Thank you, Linda.
Best of luck to you, Mr. Ramirez. Thank you for coming. All parties to that matter are excused.
You're welcome.
Thank you.
Thank you, Baba.